Welcome back to the Protecting Homeowners Podcast. I'm Marc, Dann.
Welcome to another edition of the Protecting Homeowners Podcast. Joining me are my esteemed colleagues at DannLaw today, Andy Engel, Karen Ortiz, and Whitney Castor. This is the opportunity we take each week to discuss emerging issues in foreclosure and homeownership and the legal issues that flow from that. And this week I have a thought of something we should talk about because yesterday's Wall Street Journal had a story about the growing trend of people who are not married but own homes together. And unwinding that situation can be difficult and ticklish, but it doesn't come with all of the rights and legal obligations that it does for people who are married to each other. And so we've encountered that situation often here, and I wanted to throw this out to the group to talk about what people need to know before they enter into an agreement to buy a house together with somebody with whom they don't have the benefit of marriage. Not that I'm judging, because I'm not. I'm just saying that this is a situation, that this is a generational thing. This is where my gray hair is talking, but because this wasn't something that happened terribly often when I was a young man, but it appears to be happening more and more often. So, and it isn't always necessarily people who are in romantic relationships either. There are lots of situations where people go into partnership, or they buy a home for just to save money together. So there's many reasons that could happen. But who wants to share their observations on first of all what somebody should think about before they enter into such a situation?
Well, actually, my daughter just bought a home with her fiance, and I had a long sit-down talk with them saying, look, guys, I know you intend on getting married, but you better have an exit strategy should something happen, because although you could buy this house together, neither one of you can maintain it by yourselves. So you better have an agreement laid out beforehand. And I even spoke with now my son-in-law's parents to have that same conversation with them. And fortunately, they agreed. Now, that only goes so far, though, because all that did was raise the issue and get them talking about things. Legally, that doesn't really do anything. Legally, if something were to happen, then they have to figure out how to unwind this transaction so that they don't harm themselves financially, they don't hurt their credit score, and they don't make a bad situation even worse by having a fight about the real estate. So you've got, people have to be cognizant of this issue going in. It's very easy to be optimistic that everything is going to work out. Unfortunately, sometimes it doesn't. So you've got to be prepared.
No, those are great points. The other thing I think sometimes people should think about is when there's unequal economic power between the two people that are purchasing the house, or if, for example, one of the partners in the house is call them partners for that. I think that's the easiest thing, is contributing the down payment, for example, and the other, or they're not going to be making equal contributions to the monthly mortgage payments. If there is a mortgage on the property, and there most often is, how is that? Are there going to be credits for that? Because under the law, if two people are co-owners of a piece of real estate, there is no automatic provision to account for unequal contributions to that real estate. Is that correct?
Yes, that's generally correct. And not only on that side, but down the road, let's say that the couple splits and one person stays, and then that person bears all the expense of maintaining the property, paying the taxes, paying the insurance. Those things need to be documented, one, up front, saying this is how we're going to deal with it, but two, just on the financial side, so that once you get to a point where you are going to split and just, maybe sell the property and distribute the proceeds, you've got some record of what has happened before.
What is there a presumptive way that that's split in the event that there's no agreement up front?
It's presumed to be 50-50, unless there is some evidence otherwise that one party contributed substantially, contributed more than the other.
I have a question on that. So say we have two partners who are living together and one works and one doesn't. So that means, but they're both on the title and they purchase together, like you said. So when they go to split, the person who did nothing, contributed nothing, but, maybe watch TV and vacuum, gets 50% of the person who paid that mortgage for every month. Am I understanding this correctly?
Yes, that would be the case.
Wow. Okay. Thank you. I think we need to have this discussion because I was unaware of that and I work here.
Yeah. No, and I think it is important. Although vacuuming is also extremely important, and so we certainly wouldn't want to provide no economic credit to that type of thing. And honestly, here's the other thing that applies. Contracts involving real estate have to be in writing. There's a doctrine of law, which isn't a statute at all, but it's referred to as the statute of frauds. Whitney, I'm going to put you on the spot. Tell us what the statute of frauds is and why it's important to people who are purchasing a house together.
Well, the statute of frauds requires all, like Mark said, all real estate contracts to be written down. Otherwise, they do not hold candle, or they won't hold muster, I guess, in a court of law. But I do think, absent statute of frauds issues, title is really what's gonna rule in these types of situations. If you don't have a contract between the parties going into a real estate split, or some sort of scenario with real estate, you definitely, it's going to fall back to who's on title. And the presumption is that is going to be divided equally. So now, are there limits, Andy and Whitney, that you're aware of to which for what can be included in such a contract that between two people purchasing a house?
Not really.
Yeah.
I mean, a contract's a contract. You can put just about anything in it as long as it doesn't otherwise violate the law. So the agreement between the parties as to how the property will be split or handled in the case of a separation. I mean, you can think of it like a prenup agreement to a great extent. That's just limited to the real estate. I don't believe there are any real limitations. But Mark, I've got to correct you. The statute of frauds actually are real statutes in the state of Ohio.
Oh, they are now. Okay. But it began as a concept in back in British common law or English common law, correct?
That's correct. But they have been a statute in Ohio since before you were a lawyer. So you just never happened.
It's a good thing that wasn't on the bar exam 38 years ago. I would have been in trouble. So that's good to know. Thank you, Andy. Whitney?
I was going to say, so I guess if there's no contract and we have two people on title, but one has contributed significantly more than the other party, I mean, I still think there's the possibility of filing a partition action as well, that, where the court would be involved, and then the court can determine, the split of how proceeds from a sale would be split. And that would definitely be a reason to contact an attorney to see if a partition action would actually benefit a situation like how Karen described.
Andy, what in the world is a partition action?
Well, I was just going to ask Whitney that, but now that you asked me, so a partition action is a special kind of lawsuit that owners of real estate can initiate to force a sale of real estate they own with somebody else. Basically, it's a way for joint owners who can't agree on what to do with real estate to get something accomplished. It could be used to force a buyout by one party to another, or to force a sale and then a distribution of the sales proceeds among the owners.
Karen, did you have a question related to that?
Well, I was just going to say, so that means the guy who's been paying the bills can throw out the vacuuming guy, and that's how you would get that started if they didn't agree, because, you know, the guy who's just vacuuming is not going to want to leave. That's a good gig.
Well, that's right. But that all comes down to proof as well, and everybody's situation's a little bit different. What's the difference between a partition action and a quiet title action? Because I've heard both of them could be used in this scenario.
Well, the quiet title action is used. I don't think it's used so much in this area if there's more than one person in title. But if someone claims some interest in your property, like a mechanic's lien or an easement or some type of non-ownership interest in your real estate, that you believe is invalid, you can bring a quiet title action to, quote, quiet the title in yourself and get rid of this encumbrance on your property that is not actually valid. So if, let's say, you own real estate and you and your partner have been living there for a long time, but you're not married, and the partner, leaves and wants a piece of the real estate and files some sort of lien or an affidavit against the title, the quiet title action could be used to get rid of that, so that you can, sell your property or go get a loan or what have you.
What about a situation where two people are unmarried, they own a house together, but only one of them, there's a variety of reasons this could happen, only one of them is a signer on the mortgage, but the one that is a co-owner of the property, but not a signer on the mortgage, wants to stay, and if everybody even agrees that person should stay, is there a way for that non-owner, that non-borrower to assume the mortgage and be able to stay without facing foreclosure? I'm looking at you, Karen, hoping that you might have an idea of how that might play out.
That was a lawyer answer.
Yeah.
That's where I would come in, and we would do an assumption of the loan.
Let me ask you this though: is somebody who is not a former spouse or a widow or widower, are they entitled to an assumption under Ohio and federal law?
That I'm going to say depends on what's written in the mortgage, because I've had other people assume, like I've read stories of FHA mortgages being assumed by random people. The same with VA mortgages.
Okay, so there is a potential scenario where that could happen.
Yes, I've seen it. I don't know if it's legal or not. That's for you fine folks.
I was going to say, we do see this situation a lot where there's two borrowers that and co-owners of property that are not married, who have purchased a house, and there's a default, and we're trying to modify or assume. And we've had some difficulty in assumptions where there's not a marriage or they're not a successor in interest. If there's no divorce decree, sometimes sometimes just the one of the parties quit claiming their interest and just not becoming a title owner. We've had some success in assumptions in that scenario. But also sometimes we don't have success with assumptions in that area. And when that happens, a lot of times if we represent a co-borrower, and the another borrower does not want to be part of the loss mitigation process, sometimes we still need a signature for any type of loan modification. And, sometimes explaining to that person, until we get this loan back on track, this loan's still going to report in default on your, on the co-borrower's credit. It makes sense for the co-borrower to be part of the loss mitigation process to bring the loan back current and have it be a performing loan.
So that's just another thing to think about before you end up buying a house with somebody else. Is that if you're not the borrower on the note, even though you're a co-owner of the property, you may have a more difficult time if you want to be the person that keeps the house and continues to pay on the mortgage. That the mortgage company might have the ability to say no. And look, there's a good reason for that. In some circumstances, somebody's credit and credit worthiness or income isn't as good as the other's credit or worthiness or income, and so you're going to get better terms potentially, or even approval or non-approval based on having only the one person in the partnership applying for the mortgage. You may think you signed a mortgage, and you probably did as a co-owner, because your name is going to be required on the mortgage to allow the lender the right to foreclose on the property, which is what a mortgage does. But on the note itself, there may only be one signature. So we often see that both with people who are married and unmarried. If that's going to be the case, then it's even more important for particularly for the person that didn't sign the note to have a very clear agreement and understanding in writing about what's going to happen on the back end.
Mark, I just want to point out one circumstance we haven't talked on, which is perhaps the most common one that people are going to run into, and that's when children inherit their parents' home, their parents' real estate. And a lot of times in those instances, one of the siblings will want to move in, and maybe they keep making the mortgage payments, and everything is hunky-dory, except then the other sibling says, wait a minute, where's mine? You're living in my property for free. So that's a circumstance that we see quite a lot as well. And this is where the partition action that we discussed earlier could come into play, where one party buying the other party out is important, or where some cooperation is required to permit an assumption of the loan by one of the parties. So that is a very common situation as well.
Well, and if that successor, whether it be a child or a widow or widower who's been paying the mortgage falls into default, something goes wrong. I mean, as we say around here, God forbid you get sick in America, because everybody's one illness away from falling behind on their mortgage in this country. And it seems to me, I mean, and that's probably truer than we would hope it would be. Getting that loan rehabilitated through a modification or a forbearance or a repayment plan, it is going to be dependent on that person formally succeeding the borrower on the mortgage, and that can be a little more tricky. Karen, what are some of the things to look out for in that scenario?
I'm sorry, my brain. What was the question?
The question is if somebody is seeking to become a successor in interest to a borrower on a house, somebody whose spouse passed away, or they inherited the house and they've been living there and making the payments, and the title's been vested in that person. That's not the end of the story, right? There's more they have to do in order to begin assume the mortgage, particularly if they fall behind and they need to get the loan modified.
Yes, the first most important thing they need to do is become the confirmed successor in interest. And that's done through the mortgage company, where you have to send in documents like probate documents, the certificates of transfers, death certificates. Once you are a confirmed successor in interest, you then have the ability to, can now assume the loan and hopefully modify it. And if they don't do that, then usually these guys find a law that they messed up or they didn't know about or something.
And people have ended up losing their home in that scenario, even with our help sometimes, because we can't put together the information quickly enough that's necessary, and it gives the mortgage company a lot more power. Now, this is also something that people should raise with their estate planning attorneys. So if you're intending, I have a family member. And she has 4 kids, but she wants one in particular to be able to stay in the house where she lives. If she had now she doesn't have she's paid off her mortgage, but if she had a mortgage, she'd need to take some steps. There's some steps she can take prior to her death to be able to make sure that happens. And so, making sure that you're getting good estate planning advice is important as well. Likewise, if you're unmarried and partners in a home, whether you have a will and what your will says can also be important, and also how the property's titled. What are the options for titling property in Ohio that can create some protections for a co-owner of property? Does anybody want to list those?
Well, the first thought in my mind is a survivorship deed, where you would include language in the deed that allows the property at the death of one of the owners, the property would then it would be titled, so the survivor would receive the property outside of a probate estate. So a probate estate wouldn't need to be open because the language is in the deed. That would be the best way to transfer property.
Is a survivorship deed self-executing? Does it automatically then vest the title of property in the property of the, or in the name solely of the other borrower, or I'm sorry, the other owner?
So I think, and I'm looking at Andy, I'm going to say yes, but you still have to file an affidavit with the county in order for the chain of title to be correct.
Now, there was something nifty that I worked on when I was in the General Assembly a few years ago, which is something called the transfer on death deed. How does that differ from a survivorship deed?
It's not actually a deed, it's an affidavit, and that affidavit kind of supplements the deed, if you will, and it's a designation that permits a property owner to say, upon my death, title to my property goes to whomever, my son, my daughter, my next door neighbor, my lover, whatever. But it's a way to transfer that property without.
This, by the way, this is a G-rated podcast, Andy. So go easy, okay?
It's a way to transfer real estate outside of probate, with the just with the expediency of filing a simple form that's called an affidavit for transfer on death.
Well, but why would there need to be two different vehicles? What are the downsides of having a joint and survivorship deed?
Well, for a joint and survivorship deed, both parties have to be in title on the deed at the same time. With a transfer on death designation, the beneficiary, the person who's going to get the property, does not have to be in title on the real estate. This permits the owner of the property to change their mind later and revoke that designation, or to change the names of the beneficiaries, things like that, without having to deed any present title interest to the people they want the property to go to.
Well, and I can think of one other scenario where that's really important, and Whitney sees this a little bit in our bankruptcy practice. which is that if somebody is subject to a judgment, so if somebody if your co-owner, if your joint and survivorship owner ends up getting sued and a judgment lien taken against them, or gets into some other problem with a debt problem which results in a judgment against them, that lien on the property is going to be valid and enforceable, and it's going to affect the other owner. And so this can be particularly be a problem. We've seen it in our office, actually, on a number of occasions with parents who have entered into joint and survivorship deeds with their children, who are involved in financial dealings that they're not aware of. And those financial dealings go bad, and all of a sudden there's a judgment lien that might be as big as the value of mom or dad's property. So there's some risk there. So I guess one other thing to think about before you enter into a real estate partnership with somebody is to know the person that you're getting in bed with, so to speak, to take this in the direction Andy wanted to go earlier.
Please.
That's but that's right. I mean, you're stuck with the bad financial decisions to some extent of that co-owner of real estate. And I don't know, can Whitney, Andy, can you think of any way to unwind that if that scenario were to happen with you're a co-owner of a property and your co-owner has a judgment against them? Is there any way to protect yourself afterwards?
Once that judgment lien or tax liens, there's tax liens come up a lot too. Once that's recorded, it attaches to the property interest of the debtor, so of the other person in title. And Whitney, I'll ask you, but I don't know of any way to unring that bell.
No, I don't know of a way to unring the bell. I would say that if you have judgment liens and you have judgment liens, you might want to contact a bankruptcy attorney, because there are ways sometimes of avoiding judgment liens. It just all depends.
That's right. So I think with all that said, there's a lot to think about. One, if you're considering entering into purchasing a home, it sounds great. I'm going to have extra help paying the mortgage. We're going to live in some place that's more desirable. Our housing payment may actually go down. There's lots of good reasons to enter into those agreements, even before you're married, or even if you're not going to get married someday. But there's an awful lot to think about before you do that. And if the ship goes south, if the ship starts to sink in your relationship with your co-owner, then there's an awful lot to think about, and it's really important to immediately retain counsel. So sometimes when you break up with somebody and you're not married, you don't think it's necessary to hire a lawyer. I think that one of the discussions we've had in the office today is prompted by that Wall Street Journal article, is maybe that's something that people ought to think about as well. You absolutely need to retain counsel. And by the way, we couldn't represent both of you in that situation. So you would each probably need to have your own lawyer. But if only one of you is going to have a lawyer when you're splitting up and you own real estate together, make sure that's you and not the other guy. But with that, I wanted to thank you for joining us for the Protecting Homeowners Podcast, and look forward to talking next week about some origination issues that come up.